I am very, very pleased to welcome Rene Valladares, but it's bittersweet because today is the last episode in this series. So it's very exciting and we're happy to have him here, but it is also the last episode for now, although we hope to have Rene back. After this, he will be working on the update of his evidence book. So that is something we all can be looking forward to. So, once again, remember everyone to please submit questions. We want you to ask questions. We want you to be engaged in this. So don't forget to do that. And we are lucky today, in addition to Rene Valladares, who you know is the federal public defender in Las Vegas, and the author of the evidence book that you will all be seeing a link to in the chat, and that we will be discussing today. We are happy to be sponsored by Justice Text. So without further ado, I'm going to turn it over to Devshi Mehrotra to tell you a little bit about Justice Text, and then we will start today's presentation. Thank you all so much for being here.
Thanks so much, Vanessa, and hi, good afternoon, everyone. My name is Devshi, and I'm one of the founders of Justice Text. It's been such a pleasure to sponsor today's session with Rene, and I'm excited to share just a little bit about what we're building. At a high level, Justice Text is a tool designed to help defense attorneys save hours reviewing audio and video evidence. This includes body cam footage, jail calls, courtroom proceedings, all of that. Let me just show you a little bit about what the tool looks like, and then feel free to reach out to me after the session if you have more questions. Justice Text is essentially a website. You can log in and start uploading any audio or video discovery files directly onto the system. So let's say I have a body cam file that just showed up in a case. I can go ahead, click on it, and press transcribe. After a couple of minutes, the tool will generate a rough automated transcript of any speech that it picked up on in that interaction. This transcript will not be human vetted, it's not 100%, but it does give you a high level overview of the main topics of conversation. So let's say you're scrolling through, you're interested in this section where the officer is asking for the client's license. You can just click on that, see the timestamp, and press play.
Can I have your license, please? Do you know?
If the section of the video is important for whatever reason, I could highlight that portion, press clip, give a name to my clip, and after a couple seconds, the tool will create a short MP4 snippet of just that section of the larger conversation. We also automatically detect certain key moments, and so let's say you upload a DUI case, a body cam video from that, will automatically flag for you when the different field sobriety tests were administered, the moment of arrest, when someone was administered a Miranda warning, etc. And this is what that little clip looks like.
Can I have your license, please?
So yeah, that's a high level overview of Justice Text. I know that was super quick, but definitely feel free to reach out to me afterwards. I'll leave my contact information in the chat. We actually started building this as a school project 4 years ago, and we've been working with the defense community ever since then. So thank you all for the important work that you do. And yeah, don't hesitate to reach out if we can be helpful.
Thank you so much to Devshi and to Justice Text for being our sponsor. And now I would like to turn it over to Rene. You know him from previous episodes, and you can check those out after you see this and you are missing parts of the series. You can check those out on our website. But Rene is the federal public defender for the District of Nevada and also an adjunct professor at the UNLV Boyd School of Law. And he has written extensively on evidence as well as cultural factors in criminal defense. But you don't want to hear anything else from me. You would like to hear from Rene, so I will turn it over to him.
Well, thank you very much, Vanessa, and thank you, Devshi. Devshi's product is really an amazing product, and the story about how they developed this product as a college project is an amazing one. And I think that one of the great things about this is that it's really tailored for us, for the criminal defense community. So thank you, Devshi. And thank you very much, Vanessa, for inviting me for this last presentation of the season, of the spring season. And and Vanessa and I have been talking about, returning in the fall. I really appreciate that invitation. I look forward to being with all of you for the fall series. And I already have a number of topics that I believe will be helpful to all of you as criminal defense lawyers. And I want to also thank NACDL for obviously for putting this on for the benefit of all of us. NACDL and their great work. And let me go ahead and get started here. Let me start with my PowerPoint. And what we're going to be talking today about is foundations and authentication. Now, what I'm going to be doing today, this is a big picture view of foundations and authentication. And here you have the book that Vanessa mentioned. This is a Defender's Guide to Federal Evidence. The presentation will follow the format of the book. We're going to be talking about the federal rules of evidence. We're going to go ahead and also deal with defense favorable examples. The book is full of defense favorable examples that you can use in making arguments. And also, as in the book, I'll be pointing, to potential issues and traps for the unwary and areas of opportunity for all of us. All royalties of the book, go to NACDL's Fund for Criminal Justice. So all royalties go to sponsoring criminal justice reform and again, the great work that NACDL's Fund for Criminal Justice does. Now, here is my email. As I said, this is going to be a big picture view of foundations and authentication. Foundations both for witnesses as well as exhibits. But if you want to get more into weeds, if you have a specific issue, if you have a specific case, don't hesitate to go ahead and email you, and we can correspond either via email or we can go ahead and set up a Zoom call or a phone call, whatever. But I'm more than happy to go ahead and touch base with you about any issues dealing with foundations or authentication. Now, here's the deal with foundations. The thing with foundations and authentication is that a lot of times it really seems like overwhelming. It all seems like a bunch of magic spells and incantations. And if you don't say the exact right words in the exact same sequence, then the foundation is not going to be established, or authentication is not going to take place, and that sort of thing. And really, the main purpose of this presentation is to dispel all that. That really is it's certainly a myth that has been created about evidence in general, but very specifically about foundations and authentication. And the problem is that oftentimes you look at the sources that I relied upon in setting up this presentation, great sources at that. For instance, M. Wilker Reed, which I've been using for years and years. I'm sure that you're familiar with M. Winkle Reed and the great work in the book. The problem is that a lot of times the stuff seems just really, really overwhelming. It is not easily digestible, and oftentimes it's not targeted for us, for the criminal defense community. What I'm trying to do in this presentation, again, is dispel a lot of that and try to make things as simple and straightforward as possible, and starting with how do we think about foundations? How do we think about authentication? Once we figure that out, once we have a framework on how to think about foundations, how to think about authentication, then things get a lot easier. But the key thing about this is that no, foundations and authentication are not something out there in Mount Olympus, just for the trial gods and all that. This is something that instead is for all of us. We can all do it. And this is courtesy of my daughter. I will be, wherever we're going to be talking about a defense favorable case, we're going to be having Rosie the Riveter, help us identify that particular case. and then we're going to talk about the case. I have about 10 cases that we'll talk throughout the presentation. I'm not going to cover each one of them, but they're there in your PowerPoint packet. The PowerPoint packet is designed so you can go ahead and take it to a courtroom and have there at least the principal foundations that you need to go ahead and have, so you know how to attack them when the government is doing it improperly, or when you need to lay a foundation. Now, here's our roadmap. First of all, we're going to go ahead and start with basic foundational principles, and we're going to be talking again about foundations for testimonial evidence, for witnesses, and also for exhibits. Once we talked about foundational requirements, we're going to go ahead and talk about some general matters dealing with foundations and authentication. Then what I'm going to do is that we're going to go ahead and shift to the top 12 foundations. And we're going to be covering again testimony and exhibits. Now, if you have a foundation that that you're trying to either develop or you're trying to attack, that may be more a more complex one, again, do not hesitate to reach out to me. Today we're going to be covering what I see as the 12 like basic foundations that we all should know. So let's start here with some foundational requirements. And I'd like to go ahead and always, as put in the presentation, some reference to either movies, books, or whatever it may be, where our profession is involved, specifically where criminal justice is involved, just to highlight the importance of what we all do, what you do, and how much of it pervades, our culture, our popular media, our art, our everything. The way we think is permeated by what we do. So foundational requirements. Now, a really handy way of thinking about foundations is by looking at the RASP model. There's a number of different models out there. This is the one I like, and the model basically looks at 4 different things. And you have you got relevance, authenticity, specific admissibility, and prejudice. And whenever you're looking at any piece of evidence, whether it be testimonial or exhibit, if you think of it by using this framework, the RASP framework, it's very helpful. That is, whether you're trying to introduce or whether you're trying to exclude, it doesn't matter. It's a really nice little way of thinking about foundations and authentication. So RASP. Let's go ahead. What I'm going to do is that I'm going to cover each one of these elements here quickly, and then obviously we're going to dive more deeper as the presentation goes. But relevance. Let's start with relevance. Now, I have covered relevance before at much greater length in prior presentations in this series, and the framework of evidence, the busy lawyer's framework for evidence, covers relevance, covers prejudice, and all that at a much greater depth. There I provide defense favorable cases and tips and that sort of thing. So if you have, if you're interested in taking a deeper look at relevance or prejudice, please don't hesitate to look at the busy lawyer's guide to a framework on attacking evidence. Now, as Vanessa mentioned, all these presentations are archived and you can access them. It's a great benefit, or one of the great benefits of being a NACDL member. Relevance. So according to Federal Rule of Evidence 401, evidence is relevant if it has any tendency to make a fact more or less probable, and the fact is of consequence to the action. That's your standard definition. The standard of relevance is very low, as I discussed in prior presentations. This is something that is frequently exploited by prosecutors in trying to introduce evidence that is of dubious value. So that is, again, relevance. A key thing for us to always remember is that bias and credibility are always relevant. So, if you're trying to attack that snitch, if you're trying to attack the credibility of an officer, whatever it may be, bias, credibility, always relevant. And we will return to bias later on when I'm talking about character. We need to think about bias very differently. Bias is its own animal, as you can see here when it relates to relevance, and bias is its own animal also when we are talking about character. We'll talk about character later on in the presentation. Now, so then, RASP, again, the first thing in RASP in the framework of tackling foundations and authentication is relevance. The second element is authenticity. So we already looked at relevance. Now we're looking at authenticity. And from the standpoint of the federal rules of evidence, authenticity is to satisfy the requirement of authenticating or identifying an item. The proponent must produce evidence to support a finding that the item is what the proponent claims it is. It's as simple as that. And again, all the myth behind foundations and authentication and all that, really boils down to that. What's in the left-hand column at the bottom in bold. Just, the proponent has to produce evidence enough to support a finding that the item is what it claims to be. Now, we'll talk about that, of course, later on as we talk about specific examples. Now, this applies certainly to exhibits, and it can also apply to certain testimonial evidence, in particular, when you're talking about, say, phone conversations. You have a witness testifying about a phone conversation. Well, we need to be able to identify the person at the other end of the line and that sort of thing. And again, we will talk specifically about telephone conversations later on. So that's authenticity. Now, in authenticity is in the rules of evidence, at Federal Rule of Evidence 901A. That is basically its definition. Now, the rule provides also 901A provides 901B, excuse me, provides 10 examples of how to authenticate evidence. This is just examples. And for instance, using testimony by a witness with knowledge, distinctive characteristics of an object, say a gun, a knife, or whatever. Also, you have opinion about a voice, evidence of telephone conversations, etc. That's all those are examples that are in the rule. This is a non-exhaustive list of examples. On the other hand, Federal Rule of Evidence 902A gives us an exhaustive list of examples of items that are self-authenticating. I am not going to be really covering this in this lecture. I plan on doing a more advanced presentation on foundations as well as authentication in the fall. But if again you have any issues or any questions or whatever, just don't hesitate to reach out. Amongst the items that are listed in 902A, there's actually 14 items that are listed, are such items as foreign documents, certified copies of public records, certified domestic records of a regularly conducted activity, and so on. Again, this is a category of 14, or there's 14 categories of items that, according to the rules, may meet the requirements for self-authentication. That means, of course, that you don't have to have a sponsor, you don't have to have a witness, you don't have to have, say, the custodian of records introducing those items. Now, so with RASP, we have relevance, authentication. Now we go to specific admissibility. Specific admissibility is nothing more than simply the rules that govern, a specific form of proof. A typical example, for instance, is the rules that deal with hearsay. and we'll talk about that in just a bit. But again, when we're looking at a piece of evidence, an item of evidence, whether it be testimony or exhibit, if we run it by that RASP framework, then it makes it very easy for us to identify the problems and the opportunities that we have as defense lawyers. So the SNET is specific admissibility, and an example of this is, say, the hearsay rules. Finally, we get to the P in RASP, that's prejudice. And of course, Federal Rule of Evidence 403 allows a court to exclude relevant evidence that, whose probative value is substantially outweighed by the danger of unfair prejudice, confusion, or waste of time. The last one is one that, of course, is a favorite of the judges, waste of time. That, they certainly wake up to that because they don't want to go ahead and the trial to go too long. But at any rate, prejudice is the last prong of the RASP analysis. And of course, prejudice, evidence is unfairly prejudicial under the rule, under 403, if it tends to produce a jury decision based on an improper ground, usually an emotional ground. Now, again, as I mentioned a few minutes ago, just like with relevance, I discussed prejudice at much greater length in a prior presentation, specifically the busy lawyer's guide to a framework for tackling evidence. There you will have a lengthier discussion on prejudice with examples, with defense favorable examples, tips, and that sort of thing that you can use as a defense lawyer. Now, so we covered foundational requirements. We talked about, in the foundational requirements, we talked about the RASP framework. Now let's talk about some general matters before we get into our top 12 foundations. Now, in the way of general matters, of course, admissibility is determined by the court. The court determines admissibility, not the jury. And of course, in determining admissibility under the rules, the rules do not apply. So in determining admissibility, a court can look at matters which are hearsay. The court can look at issues dealing what may be impermissible character evidence, you name it, so long as accepted from that is privileges. So in determining admissibility, that's done by the court. The federal rules do not apply with the exception of privileges. Now, a common myth that judges, believe, and once in a while you find a judge that thinks that, that in cross-examination you cannot lay a foundation. Obviously, that is false. That is a myth. You can certainly lay a foundation of cross-examination. You can introduce an exhibit in cross-examination. Another issue when it comes to general matters that comes up frequently is the issue of admissibility versus weight. And a lot of times judges really drop the ball on this, and judges will punt the issue of admissibility to the jury whenever they can. And oftentimes judges will say, oh, this is just simply an issue of weight. This is not an issue of admissibility. Well, that may be the case with a lot of things, but that is frequently abused, especially when you get to something like experts. A lot of times we will discuss this a little bit in more depth later on, but judges will go ahead and let issues of such as the reliability of an expert's opinion and what have you to be determined by the jury, when in fact this is something that they're supposed to be doing themselves. Now, in the way, again, of general matters, let's look at a framework for tackling objections. There is, of course, a standalone presentation on objections. If you want a refresher on objections, please take a look at that. And again, that's something that that is made available to you. But a very quick drive-by view of objections. If it is an objection to governmental evidence, to the government's evidence, to the prosecution's evidence, number one, consider doing a motion in limine prior to trial. If that didn't, if you chose not to, or if the evidence didn't become apparent until trial, then of course you object. At that point, move to strike. You may consider moving for an instruction to disregard. If necessary, move for a mistrial, obviously. Now, if what you have, obviously, is that, you have the government is trying to present a witness, let's say an expert, and you're challenging that, then of course, you can request voir dire on that witness. And then the other side of this, of course, is when we're trying to introduce the evidence, then if the prosecution objects and the court is not allowing you to, certainly for the purposes of preservation of the record, make sure that we all need to make sure that, we make an offer of proof on the record. Now, again, offers of proof, just like all this, the other items here in the in this slide, are items that that I handled in the presentation dealing with objections. Now, conditional admissibility. Conditional admissibility, as a general matter, that's something that we always have to be very careful about. Why? Because this is an area that prosecutors frequently exploit, and where judges end up giving prosecutors a pass. So the prosecution will be trying to go ahead and establish a foundation. The court, says that, well, it'll admit it conditionally based upon further proof from the prosecution, either the next witness or additional testimony by this particular witness, you name it. Conditional admissibility. Now, the problem with that is that oftentimes the prosecutor knows that they can't do it. They cannot prove it. They cannot go ahead and establish that additional proof necessary to actually be able to admit that. The problem for us, and this is where they know that they can do it, but still they'll exploit this, is that they figure, oh, the defense will forget about it. The defense lawyer will forget about it. The judge allowed this in conditionally, and now I'm fine. So long as the defense lawyer forgets about it, then I have to worry about it. The stuff is already in. The jury already heard it and all that. And it sounds cynical, but it's the truth. And oftentimes judges know the game. They know, and they allow prosecutors to do that. So be on high alert when the judge, allows something conditionally, allows in something conditionally based upon the prosecutor's representation, that either it will be tied in later on by this witness or another witness. Again, be on high alert, be prepared to move to strike, to move for a curative instruction, to move for a mistrial if the government fails to, in fact, tie things up, fails to, in fact, make the requisite bridge as far as conditional admissibility.
Rene, apologies for interrupting, but we do have a question from our audience. And the question is, under the federal rules, must we object until we obtain an adverse ruling to preserve error, or is it preserved when the court makes a definitive ruling?
Right, so that's an excellent question, and thank you very much for that question. Under Rule 103B, if the court makes a definitive ruling, then then you're set. And 103B reads, not needing to renew an objection or offer of proof, and it goes on to say, that's the title of that subsection, once the court rules definitively on the record, either before before or at trial, a party need not renew an objection or offer of proof to preserve a claim of error. So once that's done, then you're fine. The problem there, and that's why the question is an excellent question, is that a lot of times judges will fudge, it will seem like they made a ruling, a definitive ruling, according to the rule here, what's required is once the court rules definitively, okay? So you have to have a definitive ruling. The problem is that, again, a lot of times judges will fudge, they'll hedge their bets, and it kind of sounds like they ruled, but they really didn't. And if that's the case, you really need to press, you really need to push, you really need to go ahead and ask for the court for a definitive ruling. Otherwise, you're going to have to continue to make that objection, because under 104B, then you do not have the definitive ruling that's required to preserve the issue. But thank you very much for that excellent question. All right, so again, conditional admissibility. This is one of the traps for the unwary that we always have to go ahead and be mindful of. And the thing too is that you're in trial, and there's so many things going on. You got the prosecutor jumping up and down, you got the judge, frowning, you got your client, you got all that stuff going on. So sometimes it's really difficult to go ahead and keep track of this stuff. So make sure that, again, when you're confronted with this, that you are keeping track of it, and that if the government fails to go ahead and tie in things that you object, and if necessary, move for a mistrial. All right, now, so we talked about basic foundational principles. We talked about general issues dealing with foundations and that sort of thing. Now, let's go ahead and talk about, the top 12 foundations. Now, you may say, Rene, how in the world did you come up with top 12? Well, that's obviously what I think. You and I may disagree on a few, but I think that for the most part, we can all agree that these are the big ones. These are the big, foundations. And for the most part, once you know how to do this once, or how to object to this once, then the rest is pretty easy. Now, again, we will be covering testimony. We'll be covering exhibits as well. We'll be covering both. Now, as what I have here again, and this is separated by testimonial as well as exhibits, testimonial evidence as well as exhibits, is I have 5 in the context of testimonial evidence, and then the remainder are going to be in the context of exhibits. So let's go ahead and start with our first one there in the list. And as you can see, the way that I designed the PowerPoint is that you can take the PowerPoint as a checklist, and I will go through each one. And for the most part, each one has each one of this foundations has a checklist within its own, say, conversations or character evidence, has its own little checklist that you can go ahead and take to trial. Now, as in anything, your RASP framework is a very handy framework to analyze testimonial evidence, just like it is also for exhibits. We're looking at relevance, authentication, specific admissibility, and prejudice. Of course, when it comes to testimonial evidence, the marquee thing is going to be hearsay, but we're also going to be talking about briefly about character evidence. We're going to also be briefly talking about opinion testimony as well. Now, the basic foundations for any testimonial evidence are 3. 1, competency, personal knowledge, and oath or affirmation. Okay, so basically, the witness has to be competent, the witness has to have personal knowledge, and lastly, the witness must understand the truth, or must take an oath or an affirmation that they do understand they need to go ahead and testify truthfully, rather. So, competency, the first one, that's governed by Rule 601, and 601 basically creates a very strong presumption that that basically every witness is competent, and essentially it says very much that. Rule 601 reads, every person is competent to be a witness unless this rules provide otherwise. So there is definitely a presumption of competence. Now, there are specific provisions that deal with a judge's competence to be a witness, as Federal Rule of Evidence 605. Of course, is a very rare scenario, but just keep that in the back of your mind. A judge is not competent to testify. A judge is not supposed to testify under the rules at trial. Same thing for a juror. When it comes to issues dealing with the trial itself. Now, there are certain specific provisions dealing with an inquiry into the validity of the verdict or the indictment, and there's very specific exceptions. They're rare, but for instance, when you have a situation where there's an outside influence that was improperly brought to bear on the jury, that can be an exception to that. But now we're talking post-verdict. We're talking about something that happened post-verdict. Otherwise, basically, for the most part, the judge and the jury are incompetent to be a witness in the case. Now, let's look at some issues that come up here when we are talking about competence. This is the first case that we're going to be talking about. This is a great case for us. Usually, we are confronted with the fact that the prosecutor, drags in some snitch, who may be, the snitch may be a drug addict, a criminal, you name it. And of course, you object. This witness is barely competent. And the court will say, "Oh, sit down." The witness, there's a presumption, very strong presumption in favor of competency. That's what we usually get. Now, when we're trying to bring in a witness to testify, then courts are certainly much more willing to go ahead and disallow that witness from testifying. This is a good case for us when we're trying to present a witness who may have issues. Issues of competence, issues of insanity, of a way to get around that. Let me talk about this case, a bit. Now, here, what happened, this is a case a case that deals with a conviction for assault and assault with intent to commit murder at a prison. Now, what happened here is that the defendant, likely, and a second individual were charged with attempting to stab to death one of the inmates at the prison. Now, the defense theory was that the defendant, Mr. Likely, saw a fight between the alleged victim and the second individual. Okay, he saw a fight and that the defendant tried to stop that fight. And because of that, he went ahead and intervened and tried to stop it. Now, at trial, the defense tried to bring in the second individual, the second inmate. The inmate was going to go ahead and testify to the fact that indeed, Mr. Likely was not involved in the fight, that Mr. Likely stepped in because he was trying to go ahead and protect this second individual from the alleged victim. Now, the problem, of course, and we as a defense lawyer take our witnesses as we find them, and in this case, that second individual, that second inmate, had been previously found to be incompetent, had been previously found to be insane as far as standing trial. So you had a finding of competency, you had a finding of insanity. The prosecution sends up, prosecution objects to the testimony of this witness, and the district court says, yes, this witness cannot testify. This witness is not competent. This witness fails the test for Federal Rule of Evidence 601. Now, the defense appeals. This is a Fourth Circuit case. And on appeal, the Fourth Circuit says no. Every witness is presumed to testify unless it is shown that that the witness does not have personal knowledge. That was not the case here. Number two, that the witness does not have the ability to recall the event. That was not the case here. And lastly, that the witness does not understand the duty to testify truthfully. The witness here did. So the witness may have been incompetent, the witness may have been insane, but the witness had personal knowledge, the witness had the ability to recall, and the witness understood the witness's duty to testify truthfully. So here, the Fourth Circuit said that the district court erred in disqualifying that witness, and the error in this case was prejudicial, and sent the case back for retrial because the testimony of the witness could have been helpful to the defense. Really nice case. If you find yourself in that situation, you call a witness and the prosecution is jumping up and down. Well, this witness, is mentally defective, it's insane, it's incompetent, or whatever it may be. Let's look at this other great case here. This case doesn't deal with competence. Again, let's look at the requirements here. This doesn't deal with competence. We already talked about a case dealing with that. Instead, this case deals with personal knowledge. It's a really good case here. Now, the Lopez case here is an illegal reentry case. We're going to be talking about several cases that are illegal reentry cases in this presentation. But here what happened is that the government brings in, of course, the government had to show that as part of the elements that the defendant had been previously removed from the United States. So what they do is they bring in a border agent to testify. Now, that border agent had nothing to do with the prior deportation. The border agent wasn't there when the individual got deported, nothing. But the government figured, oh, he's a border agent. He can read the file. He can look at the verification of removal, and he can testify that, in fact, this individual had been previously deported. Well, the district court lets all this stuff in, despite the fact that the defense objects to it. The defense objects to it from the standpoint that this individual, this government witness, did not have personal knowledge. District court lets it in, and the Ninth Circuit on appeal reverses. The Ninth Circuit, holds that in this case, the agent didn't have personal knowledge. That personal knowledge means knowledge produced by direct involvement of the senses. And here the agent was not present at the deportation. The agent did not witness the deportation. And the agent even admitted that, number one, he didn't even remember this guy. And second, that that the individual's name was a very common name. So again, nice little case when you're talking about a witness, when you're trying to challenge a government witness that that you believe doesn't have knowledge as required by the rules. So those are all requirements, general requirements talking about testimonial evidence. Let's go ahead then, and within testimonial evidence, let's look at conversation. So for any conversation, when there's testimony dealing with a conversation, 4 elements have to be established. And this little handy checklist can help you when you're trying to go ahead, and if it is your witness and you're trying to prove the conversation, it can help you with meeting the foundational requirements, or it can help you also when the government has their witnesses and they're failing to go ahead and meet the requirements necessary. But you have to have the witness that testifies to when the conversation occurred, where, who was present, and who said what to whom. A lot of times you see the government putting in a witness and they'll bypass one of these elements, and then and that is that should not be permissible. Now, so then that's that's requirements for all conversations. Now, let's look at hearsay, and obviously I cannot talk about hearsay at length, Instead, if you are interested in digging more deeply into hearsay, please check out the Busy Lawyer's Guide to Hearsay. That's a whole presentation on hearsay, and that's made available to you by NACDL, by Engage and Exchange. And I think it's a really nice presentation that covers the whole of hearsay. This is a mini, little flow chart on how to tackle hearsay. First, and of course, all this stuff is discussed at length in my prior presentation. But the first issue is that, do we even have a statement? Is there a statement that qualifies? If it is, for instance, a question, question is not generally considered to be a statement. There are certain exceptions. We discussed that at the presentation on hearsay, but typically a question is not. It's not going to be a statement. So, then you don't need to continue with the analysis. But let's say there is. Then you look at, is the statement offered for its truth, or is it offered for something else? And again, as I discussed in prior presentations, this is an area that is heavily exploited by the prosecutor, especially when it comes to, oh yeah, this is part and parcel of we're not trying to show the truth of the matter asserted. We just, having the officer testify as to this to show how it is that the investigation proceeded. Well, oftentimes that's unnecessary. Oftentimes that's a violation. At any rate, so if the statement is indeed being offered for its truth, then we look at, does it fall under a hearsay exclusion, or does it fall under an exception? And then, of course, we look at confrontation clause issues. Let's look at exclusions here. And again, I deal with that at much greater length at prior presentations. But, this is, what's covered here are basically two big groups of items, of statements. One is a declarant, the declarant himself or herself, prior statement, and it could be a prior inconsistent statement, a prior consistent statement, or a statement of identification, or what usually we see more frequently for our side is opposing party statements, either statements of our clients or even worse, co-conspirator statements. Co-conspirator statements. Now, so then these are hearsay exclusion. Then we get to hearsay exceptions. And again, if you're interested in looking at hearsay, take a look at my prior presentation. And what we're going to do here, we're not going to look at each one of these hearsay exceptions, but we are going to go ahead and look at the foundations for three of them. We're going to be looking at recorded recollection. We're going to be looking at business records, and we're going to be looking at public records. Okay. And again, I wish I would have much more time to do this. That's why in the fall I do one that's more advanced, just because there's so much here to cover. But here we'll be looking at those three exceptions and foundational issues dealing with them. These are, of course, two exceptions amongst the four that deal with the declarant being unavailable. The prior ones I mentioned, it doesn't matter whether the declarant is available or not. Availability is immaterial. Now, so shifting within testimonial evidence, we talked about general issues dealing with conversations, the requirements of all conversations. We then talked a little bit about hearsay. I highlighted some of the hearsay issues that I'm going to be talking about within this presentation. Now let's look at telephone conversations. Now, what are the things that that the government generally has to establish, or we have to establish in proving up or laying the foundation for a telephonic conversation? Now, so here what we're going to do is that we're going to divide it into two different groups. The second group we're going to divide into two subgroups, but the groups are telephone conversations where the witness knows the other person. The other group is going to be telephone conversations where the witness does not know the other person. And within those, we're going to divide it into a private individual and businesses. So within telephone conversations where the witness knows the other person, basically there's this 7 steps that need to be established. And you can use them to check whether the government's covering them, or you can use them to go ahead and lay your own foundation. And again, I designed this so you can take this stuff into the courtroom and just be checking it. You know, just you have a handy little checklist so that you can follow in trying to exclude or trying to include. So you need to cover when the conversation occurred, where, the fact that the witness knows the person, how, the fact that the witness identified the voice, who else was present in the conversation, and then lastly, who said what to whom. So basically, remember, you know, I talked about 4 requirements that exist for all conversations. This is the 4 requirements, adding 3 more, steps. It's as simple as that. Okay. So again, this is a telephone conversation where the witness knows the other person. Now, here the witness does not know the other person, and this is for an individual. And this is right out of the rule. This is right at a 901B6A. Okay, and I have the rule marked for you right there. You can take a look at it. You're in trial. You take a look at the rule. You take a look also at the steps that need to be established. Again, you take the 4 steps that we talked about before. When, where, who participated, who said what to whom. Those are the 4 steps. When, where, who else participated, who said what to whom. To that, you simply add, that the witness had the number, the number of the other individual, that the witness dialed that number, or saw the number coming in, that the individual at the other end identified herself, or that there are other indicia of identification of that person. But basically, those are the steps that you're following. Now, if it is a business, it's essentially the same floor plan, with the exception that, you know, instead of identifying the individual identifying himself or herself, basically what you got is that the voice at the other end acknowledges the business entity. This is also right out of the rule, dealing with authentication. 901 deals with authentication. Now, so testimonial evidence. We talked about conversations. We talked about telephone conversations, and you have here again this handy little checklist that you can take to trial. Let's briefly talk about foundational issues that arise when talking about character evidence. Okay, obviously, we're not going to be able to talk about character evidence. There is a whole standalone presentation on character evidence, Busy Lawyer's Guide to Character Evidence, again, made available to you by Vanessa, by NACDL and Vanessa, and check it out if you have any character evidence issues. Character evidence can be a little tricky. It's once we sit down and think about it, it's pretty straightforward, but you got to work on it a little bit. But let's look at the big picture of character evidence. Here again, we have basically 5 different steps. The first step is that, is character even involved? If character is involved, does the evidence fall under an exception for the defendant or the victim? Or, does the evidence involve a witness? Depending upon whether it is the defendant, a victim, a witness, they all have their own rule, and the treatment is different for each one of those parties. Of course, a defendant can be both a defendant, and there's rules governing the kind of character evidence that can come in for the defendant, and a defendant can also be a witness. And in that case, both rules, both groups of rules would govern. Of course, we always have 404B, and 404B is the bane of our existence, is a heavily misapplied and exploited rule, usually to the detriment of our clients, although we can also use it. We can use reverse 404B. And then lastly, in our flowchart here, we look at, does the evidence involve similar crimes in sexual assault or child molestation cases under federal rules of evidence 413 or 414. If it does, then essentially all bets are off and the analysis is completely different. If that is the case, propensity evidence actually does come in. It's a really unfair rule against our clients. Our clients, that are charged with sexual offenses, if they have priors, they are judged because of that. A very unfair result in the rules, I think. Now, within character, again, I'm just doing a drive-by here really quickly, just to get the big picture lay of the terrain. But obviously, within character, we get a propensity prohibition. Character is not admissible to prove action and conformity. That applies also to prior acts. Prior acts are not admissible to prove action and conformity. Of course, we have the mimic rule. That is that if it goes to show modus operandi, identity, motive, etc., then it can come in under 4.4b. But otherwise, we get the propensity prohibition applied to character itself, and also to prior bad acts, prior wrongs, etc. Now, I briefly mentioned the character, the exceptions for a defendant or a victim in a criminal case. It's important to just remember that we have the right to bring in evidence of our client's good character, if so long as it's pertinent. If it's a violent, case that our client has a peaceful disposition, if it is a case involving fraud, that our client is honest, we have the right to do that. Of course, the problem with that, as discussed in prior presentations, is that if we do that, then the government has the right to go ahead and bring in evidence of our client's bad character, dealing with violence or fraud or whatever it is the issue that that we raised. So we have to be very careful about that. Same thing applies with the victim's character. We have the right to attack the victim's character despite the propensity prohibition. This is an exception to the propensity prohibition. We have the right to attack the victim's character so long as it is a pertinent trait. And so if it is a case where, that deals with violence, we can go ahead and bring in evidence of the victim's trait for violence. Of course, again, the problem with that is that once we do, then the prosecution can bring in evidence of the victim's peaceful character, or the prosecution can bring in evidence of our client's similar character trait, negative similar character trait. So we need to be very careful, but in the right case, this can be very much to the benefit of our clients. Now, when it comes to witnesses, the only issue that's relevant, of course, is truthfulness or untruthfulness. Now, that's it. The only issue when it comes to the character of a witness that is relevant. Now, remember, I mentioned bias, at the very beginning of this presentation. Bias is a different animal. Now, if you have the snitch there, and the snitch, has a bias because, the snitch is working a deal, has some kind of beef that is working off with the government or whatever, well, then you have somebody who's biased. And then, you can go ahead and go after that bias. But that is not necessarily attacking the character of the snitch. You're attacking really the bias of the snitch. And if you're doing that, then these rules do not apply. The whole issue is handled and analyzed very differently. Now, the reason why I did talk about character, and of course I talked about it very briefly, is that where foundational issues really come up when it comes to character is in the way that character is proven. It's in the way that character is established, okay? So in the methodology of proving character. Now, when character is at issue, such as for instance, you want to bring in evidence of your client's good character, your client's character trait for peacefulness in a case involving, say, a homicide or whatever, then you can certainly do that, as I mentioned a moment ago, but you can only do it by reputation or opinion evidence. Now, the government the opposing party, if you called in a witness to testify by reputation or opinion as to your client's good character, the government can, on cross-examination, get into relevant specific instances of the person's conduct, but they are stuck with the answer. In addition to that, the question has to be posed in good faith. But again, foundationally, we have to be very careful how it is that we're establishing character, because otherwise we're not laying a proper foundation. Likewise, when the government is trying to prove character, we need to go ahead and track what they're doing, because oftentimes, they do it wrong, and the foundation that they try to establish is the wrong foundation. They're not doing it by reputation or opinion. There are instances that are extremely rare when in a criminal case, character can be proven by specific instances of conduct, and that is, for instance, when you have, say, entrapment. Then certainly character can be proven by specific instances of conduct, but otherwise, it's very rare in the criminal arena that character can be proven, that way. With, again, the very notable exception there of, say, entrapment. So when it comes to character, really the foundational issue, and this presentation is from foundation, what we really need to be careful with is that how are we proving character? Are we laying the appropriate foundation by, using opinion, reputation, in the right case, specific instances of, conduct and that sort of thing. Again, a footnote on bias. Bias is not covered by this. If you're proving bias, then you can certainly go after it by specific instances of conduct. Now, then within character itself, character can be, this is an exception to proven character by specific instances of conduct, and that is in the case of a witness by impeachment of a criminal conviction. That's Federal Rule of Evidence 609. And I do a deep dive into 609 on the presentation in character. Now, here, again, there's a number of things that we need to be very careful about foundationally, and those are the drivers dealing with the prior conviction, and that is, what kind of case is it? In order to prove that conviction, it's got to be the right case. If the conviction, for instance, involves a crime of dishonesty, well, then, it doesn't matter if it's a felony or a misdemeanor, it's going to be coming in. But if it doesn't, then it has to be a felony. So again, we're looking at foundational issues, and that's one of them. Another foundational issue that really drives much of what we can do when it regards to, or what kind of a party can do when it comes to impeachment by a criminal conviction, is that, is the witness a defendant? If it is, then actually this is a rare opportunity, or not an opportunity, excuse me, but a rare situation where our clients receive a bit more protection than the regular witness. And if your client's going to take the stand, make sure that you read the rule, because again, the analysis is different as far as what can come in or what cannot come in with regards to the prior conviction. Specifically, a conviction that is a felony must be admitted in a criminal case if in which the witness is a defendant, if the probative value of the evidence outweighs its prejudicial effect to that defendant. So again, the analysis is a little different from your typical 4 or 3 analysis. So you just gotta be careful about that. Other foundational issues when it comes to convictions are things like the amount of time that has passed. Has the conviction been pardoned or annulled? Is it a juvenile adjudication or not? All these foundational issues are going to drive how you have to, or how you're trying to bring in that conviction, or how you're trying to exclude a conviction being presented by the government, or the government trying to present a conviction. Now, let's get into opinion evidence. And again, and as far as hearsay, character, and opinion, I'm doing, big bird eye views, just so we get kind of like the lay of the land. But when it comes to opinion and expert testimony, the bottom line is that do we have lay? First of all, is it an opinion? And then if it is it lay or expert? That's really what drives the whole foundational analysis. Now, when it comes to lay opinion testimony, and I have a whole presentation on opinion testimony, the Busy Lawyer's Guide to Opinion Testimony, both lay and expert. When it comes to lay, these are the three main foundational issues that you have to cover if it is your witness, or conversely, if the government is trying to present lay opinion evidence, these are the things that you need to track so you can object and try to exclude it. Oftentimes, the government will abuse this, especially number three. So the requirements are, one, it has to be based on the witness's, rationally based on the witness's perception. That's straightforward. Number two, it must be helpful. And then number three, it cannot be based on scientific, technical, or other specialized knowledge. It can't be based on that. Otherwise, it's really expert evidence. And oftentimes, what you will see is, as I pointed out in the presentation on opinion evidence, is the wolf dressed in sheep's clothing. The government will try to bring in expert testimony through lay witness, through, say, an officer that's testifying as an officer, not as an expert, but the government will try to bring in expert testimony that way. That's impermissible. When it comes to expert witness testimony, the foundational requirements are that the witness has to qualify as an expert. The expert knowledge must be helpful to the jury, based on sufficient facts or data, based on reliable principles and methods, and those principles and methods must have been reliably applied. Again, I refer you to the prior presentation on opinion evidence. This is an area where oftentimes, the judge will fail to go ahead and make that admissibility finding, and the judge has to make it. You need to have that finding. Oftentimes the judge will say, oh, that's up to the jury to decide. It's not. It is up to the judge to decide that. Now, let's look at refreshing recollection. Especially, I want to contrast number 5 with number 11. Oftentimes, we never get it confused by, oftentimes prosecutors do, and oftentimes judges do, so we'll be comparing both. But let's look at refreshing recollection. The foundational requirements to refresh recollection, and again, the ones that we've been talking about, again, are testimonial ones. We're going to get into exhibits here in just a minute. Now, refreshing recollection. So refreshing recollection is governed by 612. And the foundational requirements are that the witness has to forget, the examiner uses something, usually a writing, to refresh the witness's memory, and the witness testifies from memory, not by reading the document. The document doesn't go into evidence. The witness testifies from memory. If the witness's memory is not refreshed, then this rule doesn't apply. Maybe it can come in as a recorded recollection. And again, let's distinguish number 5 from number 11. Maybe it comes in under recorded recollection, but probably not. So again, just keep that in mind. Now, the key thing here, again, foundationally, and this is an area that oftentimes you'll have you have prosecutors trying to sneak in reading the writing to a jury, either by reading it or by even sending it to the jury room. Both are impermissible. The witness here has to be testifying from memory, not from the writing, and the writing certainly doesn't go to the jury room. That's refreshing recollection. Those are the 3 elements of a foundation for refreshing recollection. And if the government is not following those steps, then certainly you can object. Let's look at exhibits now. Let's look at exhibits. So foundational requirements for exhibits. Again, first of all, we start with our friendly RASP. We look at relevance, authenticity, specific admissibility, and prejudice. Now, all these are elements that we need to be looking at in exhibits. Is the government trying to bring in an exhibit? Let's analyze it under this framework, very helpful framework. Is it really relevant? Is this exhibit really even relevant? And then as far as authenticity, that's what we're going to be focusing on here in the following slides. But let's also think about specific admissibility. Is the stuff in that exhibit, in that document, hearsay? Well, then it should be excluded. Or lastly, it's a prejudicial. Now, an important distinction before we start talking about exhibits is, generally speaking, we really need to draw a distinction between admissible evidence, evidence that goes into the jury room, evidence that the jury actually gets to see and discuss in the jury room, versus an illustrative aid. Now, the government loves to bring in illustrative aids, and have the officer draw some diagram or do this or that. Now, a lot of that stuff is just simply that, illustrative aid. That shouldn't not be going back to the jury room. If the exhibit is sufficiently accurate, well, then maybe it gets admitted into evidence, but otherwise it should not, okay? And here it's important to think about like a continuum. We look at things like, is the exhibit to scale? Is it a rough drawing? If that diagram that the officer just drew there, if first of all, it's just a rough drawing or it's not to scale, well, that should not be going into evidence. That may be an illustrative aid, but that's the end of it. That should not be an item in evidence. So again, this can be used to help the witness explain what they're talking about, but it's not evidence. Now, so also as a general matter, this is another little handy little chart here, another handy little checklist. You can take this to court, to trial. When you're trying to offer an exhibit, same thing if the government is trying to offer one for you to try to exclude it. So you got basically 7 steps. Now you look at say M. Winkleread, or you look at Mowat, or you look at whatever, and and sometimes you end up with 15 different steps or 25 steps. Like, oh my gosh, that's like really complicated there. It doesn't have to be. It is made complicated. Our profession has made this stuff more complicated than it really needs to be. Basically, the exhibit has to be marked, has to be shown to counsel, to the witness. The witness identifies the item, and that's what we're going to be focusing on. Then the exhibit is offered into evidence, and then it's shown to the jury. As simple as that. Now, let's look at real evidence. Let's look at real evidence. Now, here, what I want to be doing is I'm going to be obviously talking a bit about real evidence, photos and videos, and all that. But where I want to really spend some time is in business records, public records. I want to talk about recorded recollection and summaries too, just because they're, that's where the cases show that you have just a lot of abuse, and you have those cases there outlined in my book and a defender's guide. Now, so real evidence. Now, basically, there's 2 ways to go ahead and authenticate an item, a real evidence item, a gun, a knife, whatever it may be. Can a photo be considered real evidence? Yes, it can. But basically, there's 2 ways. One is going to be a recognition of the exhibit by the witness, and again, that's essentially in Federal Rule of Evidence 901, as I said before, 901B1, testimony of a witness with knowledge. The witness recognizes the exhibit. The testimony is that the item is what it's claimed to be. Okay, that is authenticating that exhibit. It could be also, marks in the exhibit, distinctive characters and the like. That's going to be 901 B5, distinctive characteristics and the like, such things like the content, the patterns, distinctive characteristics, etc. All those are ways to authenticate an item. The second one, of course, is chain of custody. Now, chain of custody can seem very confusing and all that. It really doesn't have to be. I mean, and if you have a, I'm not going to get into chain of custody at length because, because again, establishing a chain of custody can be more than anything tedious, but it's not a complicated thing. It's just simply that it's tedious. Basically, allow me to talk just a little bit about recognition of an exhibit. I said really pretty much what I needed to say here, but just to recapitulate, the witness recognizes things. These are the 3 steps that need to be established for that exhibit to come in. Witness recognizes the exhibit. Here you have again an item of real evidence. The witness knows how the exhibit looked on the relevant date, and the exhibit is in the same or substantially the same condition. Simple as that. Basically, the witness recognizes the object. The witness recognizes it because they simply recognize it, or because it has specific features, markings, and that sort of thing. The second one, of course, is chain of custody. This is going to apply more when you have fungible items, drugs, money, that sort of thing, that are not readily identifiable. And then, of course, what you have to do, or more typically, the government has to do is establish that the evidence was in a continuous, secure control of a person or persons. But it's just really as simple as that. Now, let's look to see how this plays out in the context of photos. So on photos, of course, we analyze it under RASP. We got relevance, authentication. This is what we're going to be looking at right now, authentication. But we still have, we have specific, conditions of admissibility. In this case, they don't apply. We don't have hearsay issues. We don't have character issues. We don't have opinion issues. And then we go into prejudice. Prejudice may apply to, photos. Are they photos unduly gruesome? Are they cumulative and that sort of thing? So again, even with an item in either real evidence or a photo or whatever, we need to run the RASP analysis. Now we did that, let's say. So then we're focusing right now on the second element of RASP, authenticity. So what needs to be established, of course, is that the witness recognizes the scene, the witness knows how the scene looked on that relevant date, and the photo, video fairly and accurately depicts the scene. It's as simple as that. Okay. Now, here you have again a nice little checklist where you can be checking in how you are introducing that photo, or how the government is screwing up and introducing the photo, and you can object and get that photo excluded. Now, let's say the government, from an authenticity standpoint, is able to go ahead and authenticate it. Still, under RASP, you can go ahead and object based on, say, prejudice, like we discussed. Are the photos unduly gruesome or whatever it may be. Now, so here, let's talk about business records. So let's spend a little time talking about business records, and let's talk about a couple of cases dealing with business records, because you get into say a fraud case, and the government is going to go ahead and just bombard the jury with hundreds of records. So again, we run our RASP analysis, relevance, authenticity, special conditions for special admissibility issues, and prejudice. Now, when it comes to RASP and in the context of business records, the main issue under the S is going to be, of course, hearsay. Now, so let's talk about authenticity first. So first of all, a record is admissible if it is made at or near the time. So there's a time component there. The second one, made by or based on information transmitted from a person with knowledge. So you got a time component and a person component. Third, those records must be kept in the course of a regularly conducted business activity kept in the course. And then fourth, that the records were made as part of the regular practice of that business. Now, a nice little way to remember this, and again, you have here your little checklist, is the acronym CRAP. And usually that's what it is. That's usually what the government is trying to introduce by CRAP. Okay, so you got K, kept in the regular course of business at or near a time of the event by a person with knowledge. Okay, and this is something that Professor Barkay from the University of Hawaii came up with. But that's a nice little way of really, I mean, you look at the rules, and sometimes you look at the hearsay exception dealing with business records, and you get a headache because there's, you know, it seems so confusing, but it's not. It's as simple as the CRAP acronym outline right here. Now, so that is the piece dealing with hearsay when it comes to business records. Now, how about authenticity? Well, you know, authenticity has to be established by testimony from a custodian of records under Federal Rule of Evidence 901 A1. That can be, you know, somebody that has knowledge of the records, or it can be done by under Federal Rules of Evidence 902.11 by, you know, by certification of the records. Now, in that case, reasonable notice and opportunity to inspect must be given. So then, a couple of things here before we talk about a few examples where issues come up that we need to be mindful of. A record does not come in if the witness, if the opponent, excuse me, shows that the source of information or the method of preparation of the records lacks trustworthiness. That's something that we should always be thinking about. You know, so is this business that the government is getting the records from? What kind of record keeping do they have? You know, is it a mess? I mean, did they have any kind of system there? Well, if that's the case, then let's go ahead and testify that, you know, there's a lack of trustworthiness there, and that the government needs to prove that, you know, that that there is. In addition to that, it cannot be prepared in anticipation of litigation. Moreover, cannot contain hearsay within hearsay. Let's talk about a couple of examples here. The last example is a great example here, and here in this case here, the defendants were convicted of various drug crimes. Now, what happened here is that law enforcement received information from a company that one of its employees of the company, that one of the company's employees was ordering hydriodic acid that's used in the manufacturing of methamphetamine, and that the employee was doing it without permission. So the law enforcement investigates, and in fact, Mr. Laster ends up being charged and, well, eventually convicted. And what happened at trial that got him convicted is that the government, of course, introduces a bunch of records, and these are purchase records from the company. The government brings them in under Federal Rule of Evidence 8036 through the detective, okay? So the detective here is the one that is introducing the record, you know, and it's a typical thing that the government will do. Oh yes, you know, the detective is basically a Superman. So not only can he testify about the investigation, but he can also testify about the record keeping methods of the company. Well, the defendant, of course, objected. The district court said, you know, sit down, you know, the records come in. And on appeal, however, the defendant argues that the detective was not qualified to admit the records. Why? Because the detective really didn't know how it is that the record keeping system operated for that company. And the circuit says that in theory, an agent could could go ahead and get the records admitted, because what the rule requires is that they be admitted by testimony from a custodian or another qualified witness, or as I mentioned before, by certification under Federal Rule of Evidence 902. Now, the rule talks about other qualified witness. It's got to be a qualified witness. So the government's arguing here that the detective, the agent, is a qualified witness. The district court felt that it was a qualified witness, but the Sixth Circuit said, no, come on. This guy didn't know how this record keeping was kept by the business. He got really no idea of the methods they used in keeping the records, etc. Consequently, the evidence was inadmissible, and the district court erred. Now, let's look at another typical problem that comes up foundationally when it comes to business records, and this is the Williams case. And this is a classic example of items that cannot come in, of records that cannot come in because they were prepared in anticipation of litigation. So what happened here is the defendant was a truck driver, and he was contracted to drive a load of products from place A to place B. Now, the defendant never delivered the load, never delivered the tractor trailer, etc. So the defendant gets charged for transporting a stolen vehicle in interstate commerce. So now what happened here is that the government introduced evidence dealing with the value of the vehicle at trial. Now, the way they did that is that they did it through a business that was the business deal with trailer. It was a trailer maintenance facility. So the government went to this facility, and basically they got an estimate on how much that truck would have been. And the owner of the business didn't testify. Instead, the government, they had their paper, and they figured, hey, this paper should do, and they should come in to establish valuation of that truck. The defense objects, hey, this is not proper. This record was prepared in anticipation of litigation. This was not in the regularly conducted course of the business, etc. It should not come in. District court says, oh, sit down, you're wasting my time. Of course it comes in. And but the Fifth Circuit didn't see it that way. And the Fifth Circuit said that was error. The record there, which was about the fixed market value of the stolen truck, should not have come in. According to the circuit, that record did not fall under Federal Rule of Evidence 8036 because it was not made in the regularly conducted course of business. Instead, it was prepared for the purposes of trial. If it was prepared for the purposes of trial, it is prepared in anticipation of litigation, and the rule does not apply. Now, let's look here at another nice example and again, I hope you enjoyed the Rosie Riveter examples, courtesy of my daughter. But here, this is another really good case. And what we have here is that a record the government is trying to introduce, if it contains hearsay within it, if it contains double hearsay, then it should not be coming in. Now, a record, a business record is an exception to the hearsay rule because it's felt that, a business is, that if something is being conducted in the regular course of business, a business is going to be careful about what goes in. There's guarantees of trustworthiness and that sort of thing. But when you have, for instance, somebody else, a third party that provides information for the report, then there's a problem. The government has a problem. And that's what happened here. In this case, the defendant was convicted of mail fraud. And at trial, the government, it was mail fraud and dealing with fraudulent bankruptcy cases. The government introduced PACER records that showed that the defendant's email was tied to a PACER account that was used to access this fraudulent bankruptcy cases. So the government brings in this evidence, brings in these records. The records are PACER records. The records, however, contained hearsay from a party that was not part of the organization. Okay. Now, again, the defense objects. District court overrules the objection, but on appeal, the 10th Circuit says no. Double hearsay in the context of a business record exists when the record is prepared by an employee with information supplied by somebody else from outside of the organization. And in this case, if the person who provides the information is an outsider to a business and is not under a business duty to report, to provide accurate information, then the reliability rationale that underlies the business record exception ordinarily does not apply. Consequently, the exception does not apply, and the district court committed error in allowing the evidence in. Okay, let's go ahead and go to number 1 in our list of the top 12, and that's public records. Now, public records are very much like business records in as much as records can come in if they meet either 2 criteria. Public records can come in if they meet either 2 criteria, either the record setting for activities of a public office or agency, or they are matters observed in the course of official duties. Now, parenthetically, Federal Rule of Evidence 902 provides several instances where a public record may be self-authenticating, where you got like sealed records, certified records, that sort of thing. But again, this is something to keep an eye on. The government oftentimes will try to get in records under Federal Rule of Evidence 902, but yet they haven't met all the requirements. This is something where it really pays off for the government trying to go ahead and bring it in, just to look at the rule and make sure that they're covering everything they need to go ahead and cover. Now, importantly, within the public records is a law enforcement exclusion. Under Federal Rule of Evidence 803(8), bars the government, bars the prosecution in a criminal case from introducing factual findings resulting from an investigation. It's an important exclusion that applies to our benefit. We can actually use the records against the government. The government cannot use them against us. And before I give you an example, let me just make point out 3 things here. This are the same as in business records. Number 1, if you're able to show that those public records were not systematically kept, there's a problem with the way they were prepared, maintained, kept, or whatever, then you got grounds for objection that the records lack trustworthiness. In addition to that, records cannot be prepared even if they're public records in anticipation of litigation. Lastly, always look out for hearsay within hearsay. So let's talk about, this is a nice case here. And what we got here is that the defendant is convicted here of marriage fraud and making false statements in the context of an immigration document. So what happened here is that immigration became suspicious that the defendant had contracted marriage fraudulently, and they felt that the marriage was a sham. Now, the defendant testified that no, it was not a sham, that the parties intended to go ahead and live as husband and wife when they were married, and that they, that they lived in the same residence, that slept together, that sort of thing, trying to establish that in fact the marriage was legitimate. To try to rebut the defendant's testimony, the government introduces over objection an INS record, sworn record by the defendant. So this is something prepared by the defendant. Now, in the document, the defendant made contradictory statements that seem to support the government's case, and contradicted also the statements that the defendant had made during his testimony. For instance, in his testimony, the defendant had testified that, while yes, there was the intention to marry, and while they had lived together, they had not lived together continuously, etc. In the statement, that's not what the defendant has said. And so the government wants this document in, and the government is able to bring it in at trial. And, they're bringing it in under Federal Rule of Evidence 803A, public record. The defendant on appeal argues that the exhibit wasn't properly admitted under the rule 803A, and the Ninth Circuit notes that in this case, that the 803A does not apply to the subjective observations, summaries, opinions, or conclusions of law enforcement. In this case, when the defendant had been interviewed, and this was the document the government was trying to interview, it was an INS record or sworn statement. And here, what had happened is that the defendant was interviewed by immigration officers, and by then, the proceedings were already adversarial. Immigration already suspected that the defendant may be committing marriage fraud and consequently immigration fraud as well. The context and the nature of the interview were adversarial. They were trying to pin down the defendant. So the circuit said, no, this falls squarely within the public record exclusion to the rule. And again, Federal Rule of Evidence 803A bars the prosecution in a criminal case from introducing factual findings from an investigation. And that's exactly what happened here, according to the court. So according to the court, the exhibit fell within the criminal case exception to Federal Rule of Evidence 803A, and the district court erred in presenting it. Now,
Rene, my apologies again
Yes,
for interrupting, but we do have another question from the audience. And it is regarding Facebook messages. And the individual asked, would the government be more likely to enter Facebook messages between the defendant and a witness as conversations through the witness? Because the hearsay included within the business record of the account that could not be certified would most likely make the record inadmissible.
That's right. So what they can do is, as they can try to do a number of things. One, they can try to bring in all the records, as a business exception and what have you. But then they would have to go ahead and, first, under RASP, they would have to show that they're relevant, that they're not prejudicial, and they would have to go ahead and show that, whatever the contents are not hearsay. Now, the hearsay argument, of course, would be it's a statement by the defendant. Okay, and I imagine that the argument would be that whatever the other party is responding is simply contextual. So you have admissions of the defendant, and then you have the context. So I would imagine that's how the government would try to get around that. But still, you have, of course, that deals with the hearsay issue. You still have the authentication issue. They would have to go ahead and have either a custodian or certification or whatever it may be. But of course, they can try to go get the conversation. through the other party, and they can go ahead and they can use the Facebook messages to refresh the individual's recollection if they forget. In that case, the Facebook messages wouldn't come in. So that's a long way of answering that question. I hope it did. There are ways, again, if the issue is a potential hearsay objection, that the government may be able to meet the hearsay objection by arguing that, again, that was an admission. In the case here in Orellana, this was also an admission of the defendant. The problem that the government had here is that it was a public record, and they were trying to get it under 8038 public records, and this fell squarely under the public record exception. But if if our participant asks the question, if they have an issue that goes beyond what I answered, by all means, please reach out, and I can go ahead and talk to you about Facebook messages. I can send you a couple of articles on the authentication and admissibility of Facebook messages and that sort of thing as well. So Vanessa, I hope that answered the question there.
I think so. Thank you, Rene.
Oh, no problem at all. Now, just briefly here, this is also another, this is another good case, and this is also a public records case, the Marquette Piatto case. And here, what this emphasizes the fact that, if the government's trying to use as an exception, hearsay exception, or, grounds for admissibility, Federal Rule of Evidence 8038, that whatever is contained in that document has to pass, the hearsay exception. If there is, let me give you an example here, and you see exactly what I'm talking about. Again, example here being Marquette Piatto. This is another immigration case here, and what happened is that the defendant was charged with being removed alien that came back to the country. On appeal, the defendant argued that the district court erred when it admitted under the public records exception, Federal Rule of Evidence 8038, the defendant's application for status as a permanent resident. Okay, so this is an application for status as a permanent resident. Now, this is different from the prior example from Orellana Blanco. Why? Because in Orellana Blanco, remember, at that point, immigration already suspected criminal activity. Immigration was interviewing the defendant in the context of what potentially could be a criminal act. Consequently, that fell squarely under the 8038 exclusion. That is, in criminal cases, the prosecution cannot use the public record against us if it includes factual findings from an investigation, like I noted there in the prior case. In this case, however, that was not the case here. In Marquette Piatto, this was simply an application for status. So when the defendant made that application, the defendant was not being investigated. So you're not going to have that exclusion there, the public record exclusion, the law enforcement exclusion under the public record. The problem here is that the application for status contained hearsay that did not come in under the public records exception. Specifically, what happened here is that the Ninth Circuit noted that, yes, the application concerns the activities of a governmental agency. So far, so good. 8038 applies. But the only part of the application that is relevant here was a statement from a hearsay statement from an individual saying, from a third party, saying that the defendant, Mr. Marquette Piatto, was born and raised in Mexico and was a Mexican citizen and not an American citizen. Okay, so that was contained there in that immigration document that the prosecution wanted in. The Ninth Circuit says, no, that is hearsay, it's really double hearsay, is hearsay from a party that is not a governmental entity that cannot come in. In this case, the circuit found that the admission of that application was prejudicial and reversed and remanded the case. Okay, we have just a few minutes here, but I want to cover a couple of things here. First of all, we have emails. For emails, as far as authentication, it's going to depend upon whether the email is outgoing or incoming. If it is outgoing, what has to be established is reliable knowledge of the recipient's email and the part of the person that sent it, and the reverse. If it is an incoming email, what has to be established for authentication purposes is reliable knowledge of the sender's email. Now, always bear in mind that we need to go ahead and look out for hearsay, with the emails, oftentimes what you want to have is, just like I mentioned when we had the great question by one of the audience members. A lot of times when it comes to emails, Facebook messages, or something like that, you may have issues dealing, or an exception, an exclusion based on party admissions. Now, recorded recollection. Really quickly here, again, I mentioned that I wanted to distinguish it from number 5, refreshing recollection. Oftentimes judges and prosecutors confuse that. They're completely different things. Refreshing recollection is not a hearsay exception. It's not a hearsay exclusion. It's just simply a device to help the witness remember. Recorded recollection is indeed a hearsay exception. And what has to be established is that once that person had knowledge of the event, the witness now cannot remember, even after having their an attempt at their recollection refreshed. Witness cannot remember. The witness, however, had made an accurate memo of that event at a time when that was fresh in their mind. Now, those are the 4 elements, and you can track them as the government is trying to, to argue recorded recollection. But always remember that the record is only read into evidence. It doesn't come in unless, say, if the government is trying to introduce it, the record is read into evidence, assuming it meets all the foundational requirements, but it is not admitted unless you want it admitted. Now, you can request for its admission as being the opposing party. Now, this is a nice case that illustrates the point that in order for this rule to be triggered, number 2 has to apply. The witness cannot recall the events accurately. Now, what happened in this case is that there was some memory issues. So the witness says in the plural, there were some memory issues, but there was really not, it was not established by the government that the witnesses really have forgotten. That was not established. Number 2 was not established. And in this case, the district court let it in, despite the fact that number 2 was not established. The circuit court, the 10th Circuit says, no, that was error in the part of the district court. The district court should not have permitted that. Now, the last one on our list of 12, and that is summary. And again, this is a rule that is heavily exploited by the government. Of course, the rule says that when there are records of voluminous content, that they can a summary can be prepared by, say, a government agent. Of course, we can use this rule as well, but this is usually in the context of an FBI agent in a fraud case, preparing a summary to prove voluminous content. There's thousands and thousands and thousands of pages, and they cannot be conveniently presented in court, examined in court. Consequently, they're allowed under this rule, but the requirements are they cannot be conveniently examined. The witness has examined the data. The witness is able to produce a summary, and the exhibit is a fair and accurate summary of the underlying information. Now, the proponent of this evidence has to make the originals or duplicates available for examination. And more importantly, the underlying evidence has to be admissible. I put 2 cases here in my PowerPoint that you can use. These cases show that the government cannot use this to try to bring in hearsay. Okay, oftentimes the government will try to go ahead and do that. They'll try to go ahead and basically Trojan horse hearsay statements by using the Federal Rule of Evidence 1006 that is not permitted. That's not the case. These 2 cases, help you grasp that. There's nice little examples of that. I'm not gonna, talk about them in detail as we're coming here to an end of our time. But these 2 cases gives us 2 important lessons for us as defense lawyers. One, that the evidence that the government is trying to admit has to be admissible. Hearsay evidence is not okay. Number 2, the government cannot use the FBI agent, as kind of to give like a surrogate closing argument. That is impermissible. That is not something that really can be done. And if you have the situation, the second case, in one case, is a good case on that. The Oros case is a good case that shows how hearsay cannot, be utilized. In one case is a good case that shows that hearsay cannot be utilized. In addition to that, that the government cannot use Federal Rule of Evidence 1006 as a surrogate for closing arguments. As an, as the FBI agent, making a closing argument there on their own. Foundations and authentications are something that we can all master. We can all do it. There's again the myth out there that this is something that is, it's very frustrating and confusing and this and that. Well, no, we can all do it. It's really pretty straightforward once we work at it. If we put the time into it, it's very straightforward. I'm very much hoping that the PowerPoint that I gave you, with the checklist and what have you, will be of assistance to you. And here in closing, I cannot thank all of you enough, and I cannot thank you enough, Vanessa, for having me. And I look very much forward to seeing all of you in the fall again.
All right. Thank you so much, Rene. We have one last question, if you're willing to field it briefly.
Absolutely.
And a viewer asks about the potential of fake emails and the worry that someone, a witness could manufacture or fake an email as evidence against a client. And so the viewer's question was if you were familiar with objections requiring best evidence from actual email or a way to invoke the best evidence rule in that situation, as opposed to taking the prosecution taking the word of the victim that this was an email they received.
That's right. So there's 2 ways of looking at it, and really the easiest way, and but the best evidence, I can talk to our viewer here. If the viewer can email me, I can talk to him about, separately, but nonetheless, just a straight up way of dealing with that potential problem. If there's issues, if the government is trying to bring in the actual records, I imagine they're trying to do it under business record or whatever, if there's any way that you can show that those emails, there's some kind of indicia of lack of reliability, then, you can go ahead and attack them. And if you can do that, then they should not be coming in under, business records. So you can do that. It's a little tougher to do it under best evidence. I can talk to you again, separately about, how to potentially do that. But again, it's tougher. You're more straight up, route is just if you can show that, that there's any kind of indicia there that, those records were either maintained, produced, or whatever in a fashion that basically that puts them in question, then you can attack them as not having as lacking trustworthiness, and they should be excluded under 803.6. So I hope that helped there, Vanessa.
I think that was incredibly helpful, and I think that answers our viewers' question. And I just want to, in wrapping up, thank you once again for doing this. It's an incredible resource. I want to thank our sponsor, Justice Text, for making this possible.